A tiny life vanished, and every new detail makes what we thought we knew feel like a lie. Hit subscribe and turn on the bell now so you get first-hand updates on this story as it develops. On September 4th, in a Riverside County courtroom that has been watching this case with tense attention, both Jake and Rebecca Haro entered not guilty pleas to the charges lodged against them. They did so under separate counsel, each represented by their own attorney, a procedural detail that signals both the seriousness of the allegations and the distinct legal strategies likely to come. The not guilty pleas are expected in modern criminal proceedings. They do not resolve guilt or innocence but instead launch the matter fully into the adversarial process. Discovery, pretrial motions, hearings, and, unless resolved earlier, a trial. For a case as emotionally fraught as this one, a missing infant who investigators now say likely did not survive, those first courtroom moments carry enormous symbolic weight. They are when the public's raw outrage and grief meet legal rights and due process. The accused are entitled to a vigorous defense, to see the state's evidence, and to test that evidence through cross-examination. The state, in turn, carries the heavy burden of proving every element of its charges beyond a reasonable doubt. The separate representation is more than just a formality. Different counsel means different legal lenses will be brought to bear. One defense may emphasize procedural flaws, another may press for alternative explanations, and both will challenge the chain of evidence the prosecution assembles. In high-profile cases like this, defense teams often immediately begin attacking investigatory steps, the timing of search warrants, the handling of electronic evidence, or the admissibility of statements. Expect early filings contesting things like the scope of searches, the lawfulness of arrests, and the use of any statements made by the defendants. The not guilty pleas set the stage for those contests. Meanwhile, prosecutors will be compelled to show the depth of their investigation, the interviews, the forensic analyses, the surveillance corroboration, and any physical traces found in seized property. The courtroom is where all of that evidence will be laid out, piece by piece, measured against the legal standard the state must meet. This first section of the legal drama is not only procedural. For the community still grieving for Emmanuel, the not guilty pleas can feel like another sting, a step that delays the kind of clear accountability many want. For legal actors, however, the pleas simply mark the beginning of a process designed to ensure fairness. The plea leaves open every legal option for both sides: dismissal motions, plea negotiations, pretrial rulings on evidence, and eventually, if the case reaches that point, a jury's verdict. That skeletal phase of the case will determine what the public eventually knows in detail. Many of the most sensitive investigative findings are not released at arraignment but are instead revealed through discovery, which defense counsel will pore over for months. The not guilty pleas therefore represent both a legal protection and a promise that the truth, whatever the facts may prove to be, will be tested in court, under rules designed to keep the process fair even when the community is demanding speed and answers. One of the first procedural ripples from the arraignment came in the form of venue motions. Rebecca's attorney formally requested a change of trial location from Riverside County to the nearby city of Banning, citing the Haros connections to Cabazon and arguing that pretrial publicity, community sentiment, and local knowledge could prejudice jurors if the trial were held in the county seat. Venue change requests in high-profile matters are common. Defense counsel argues the community's exposure to media and social chatter makes it impossible to seat an impartial jury locally. Prosecutors, conversely, will argue that venue should remain where the alleged criminal acts and investigatory efforts occurred and where the impact on the community is most directly felt. Whether the judge grants the venue transfer will be a telling indicator of how the court balances local interest in accountability against the defendant's Sixth Amendment right to an impartial jury. From a strategic perspective, asking to move the trial to Banning is more than a legal tactic. It's a bit to shape the narrative terrain where jurors will evaluate evidence. Defense lawyers often prefer a district somewhat removed from the most intense media scrutiny, hoping that calmer local discourse will produce jurors who can focus on the evidence rather than headlines. For prosecutors and victims' advocates, keeping venue close to the scene reinforces the idea that the community most harmed has the primary stake in adjudicating the matter. Beyond strategy, the motion also reveals how the defense is thinking about the social dynamics of this case. The ways in which local affiliations, social networks, and online neighborhoods could influence juror impressions. Judges evaluate such requests by measuring the extent and depth of pretrial publicity, the community's exposure to potentially inflammatory information, and whether prospective jurors can still promise to be fair. A change of venue would delay scheduling, impose logistical burdens, and alter media calculations. A denial would keep the trial at the heart of local attention, and keep the families and community living in the same media environment as the proceedings. If the courtroom is where legal technicalities play out, the trial's emotional center shifted dramatically during recent testimony from Emmanuel's grandmother, Mary Buchanan. Her words cut through procedural noise and moved the trial into raw human territory. Mary testified with palpable grief, recounting scenes that painted a picture of family strain, domestic abuse, and warnings that she says went unheeded. Her testimony is not merely a narrative, it's a moral ledger, a sequence of names, dates, bruises, and missed chances that force listeners to confront consequences rather than abstractions. She described pleading for the child's safety, the strain in family interactions, and the heavy weight of watching warning signs that did not prompt decisive institutional response. That testimony shifted the trial's tone. What had been largely legal argumentation now carried the weight of a grandmother's grief and the moral urgency of someone who believes the system could have done more. Mary's testimony carries multiple functions in court. Emotionally, it connects jurors and the public to the human reality behind the charges. Legally, it can help prosecutors establish context, a pattern of domestic dysfunction, knowledge of risk, and repeated domestic incidents that might bolster a narrative of neglect or ongoing abuse. Witnesses like Mary provide texture to the timeline investigators are assembling. They recollect arguments, events, and physical signs that may not appear in digital logs. At the same time, defense counsel will challenge her perceptions, timing, and recollections, pointing out that memories can be imperfect, that family disputes are often messy, and that grief reshapes how events are recalled. Still, Mary's testimony resonated precisely because it articulated a central question behind the prosecution's theory. If warning signs were present, who had the duty, legally and morally, to act, and why did those signals not trigger greater protective steps? Those questions echo beyond the courtroom. For neighbors, for social workers, for pediatricians who might have seen the child, Mary's words are a prompt to reflect on what they saw and what they did. She insisted, in plain terms, that Rebecca was pressured into taking a polygraph and that Jake refused one unless his attorney was present, details that carry legal and psychological weight. Whether or not polygraph evidence is admissible in court, the claim that one parent was pressured into such a test while the other flatly declined shapes the public understanding of cooperation and culpability. Mary's testimony became a fulcrum. It both humanized the tragedy and sharpened the moral lines the jury and community will have to reckon with. The polygraph matter itself raises difficult issues. Mary said Rebecca was pressured, perhaps by investigators or by circumstances, into taking a lie detector exam at a time when the investigation was active. Polygraphs are controversial. Many courts treat their results as unreliable and inadmissible, yet investigators sometimes use them as an investigative tool to elicit information or to identify inconsistencies. The claim that Jake refused a polygraph unless his lawyer was present is equally telling. That refusal can be couched as a legal right, one protected by counsel, but public interpretation often reads such refusals differently, as a sign of evasiveness or defiance. In legal practice, defense attorneys routinely advise clients to avoid any unsworn, unrecorded interviews and to insist on counsel. That's a crucial protection against self-incrimination. However, where public trust is already frayed, such legal prudence can be read as obstruction. The court must therefore navigate not just the legalities but the public's hunger for clear answers, a difficult balancing act. One of the most haunting technical details in the case is the timeline. Investigators now say Emmanuel may have vanished on August 5th, yet he was not reported missing until August 14th, 9 days unaccounted for. That gap is not just a procedural puzzler. It is central to the prosecution's theory and to community outrage. Time matters hugely in missing person investigations. The first hours and days are when witnesses are freshest, when surveillance footage is most likely to be intact, when dogs and searches have the best chance of success, and when perishable medical evidence can still give answers. A 9-day delay raises immediate questions. What happened during that period? Who had contact with the child? Why did the parents wait? The prosecution argues that this delay allowed for concealment and cover-up, time in which evidence could be destroyed or moved, while defense counsel may have different explanations, ranging from confusion and trauma to other, more exculpatory rationales. Explaining such a delay is difficult. If a child disappears suddenly, typical instinct is to report it quickly. The decision not to do so is one of the hardest elements for the community to reconcile. Investigators will comb communications records, phone pings, and surveillance timestamps to reconstruct that period minute by minute. They will interview friends, relatives, and neighbors to learn who visited, who contacted whom, and whether any third-party movements occurred. In many prosecution narratives, unexplained gaps in time are where the most incriminating evidence often hides. The hiding of items, the removal of evidence, or the coordination of a cover story. For the public, the 9-day gap is often the most chilling detail, the time during which Emmanuel's fate may have been decided and hidden. That gap is what shifts the investigation from a hope of rescue into a search for truth and, if the evidence supports it, into a homicide case. Compounding that timeline problem are the inconsistencies discovered in Rebecca's abduction story. Investigators reported that her accounts shifted, details about where she was attacked, how long she was unconscious, and whether she saw a vehicle or stranger changed in multiple tellings. In law enforcement, shifting stories are often an early red flag, not proof of guilt, but a reason to investigate more deeply. Memory under stress is fallible, yes, but deliberate or repeated changes in fundamental elements, like direction of approach, duration of alleged unconsciousness, or whether a vehicle was present, can indicate fabrication or an attempt to align later statements with newly learned facts. When investigators cross-checked Rebecca's account against surveillance footage and witness statements, the contradictions became more than memory lapses. They fed a prosecutorial narrative that the abduction story was constructed. Defense teams will push back hard on how those inconsistencies are interpreted. They will cite the science of trauma and memory. High stress can fragment recall, and people sometimes fill gaps with confabulations. They will also argue that public scrutiny and media exposure can reshape recollection. Prosecutors, by contrast, will use inconsistencies to challenge credibility and to argue that the inconsistencies are not minor but foundational, undermining the entire abduction claim. The jury will ultimately decide which view to trust, but for the investigative timeline and for the community's sense of what happened, those inconsistencies are a key reason the focus turned inward to the family rather than outward to unknown suspects. Both parents were ultimately arrested as authorities declared that Emmanuel likely did not survive. The arrests on serious charges, including murder and filing a false police report, reflect investigators' conclusion that the missing child report did not match objective evidence and that the most likely place to find truth was within the household. Arrests of parents in missing child cases are always wrenching, because they tear at deeply held notions about parental protection. But when forensic indicators, prior histories, and inconsistent statements converge, law enforcement's duty is to act where probable cause exists. Arrests are a step toward legal resolution. They are not the end. They raise new questions. Will the accused cooperate now? Will new evidence surface from the searches and forensic processing? The legal process will allow those questions to be tested publicly, but arrests also mark a new phase, one in which the family's private story becomes a public legal record. Adding to public concern are resurfaced records of Jake's prior child abuse charges in 2023. The earlier case, which reportedly involved severe harm to another infant, has become central to how the community views current allegations. A prior conviction for child cruelty is not automatic proof of later guilt, but it is relevant for pattern assessment and for evaluating risk. Many neighbors and advocates see the prior case as evidence that authorities missed an opportunity to intervene decisively and protect subsequent children. Prosecutors have not been shy in highlighting that prior history as part of their broader case narrative, arguing that lenient outcomes can have cascading consequences. That argument is politically and emotionally potent, It reframes this tragedy as not only a family failing but a system-wide one, where earlier decisions about punishment and supervision may have contributed to later harm. The community's reaction to all of this has been sustained and public. Vigils, memorials, and protests have kept Emmanuel's name visible and kept pressure on investigators and officials to find answers. Public grieving is natural, but it has also become a force for accountability, a way for neighbors to express both sorrow and outrage. Social media amplified both grief and scrutiny. Hashtags trended, petitions gathered signatures, and local voices demanded transparency. That public pressure has helped ensure the case remains a priority for law enforcement and for policymakers, but it has also risked muddying the investigative waters with speculation. The balance between keeping pressure on authorities and avoiding the contamination of evidence is delicate, and both the community and officials must navigate it carefully. In the end, 9 unreported days, a grandmother's searing testimony, resurfaced prior convictions, shifting accounts, and community outrage have made the Emmanuel Haro case far more than a single criminal prosecution. It is a test of legal process, of institutional responsibility, and of communal conscience. The trial will proceed through calendared hearings, discovery battles, and, if necessary, a jury's verdict. But even before a courtroom decides, the case has already pushed the community to ask uncomfortable questions about prevention, reporting, and the cost of silence. If justice means anything here, it must answer not only whether the accused are guilty, but also whether systems and neighbors could have acted differently to prevent a tiny life from ending prematurely. Strong wrap-up. This story has shifted from a missing child alert to a deeply painful criminal case that implicates family choices and systemic failures. The not guilty pleas mark the formal start of legal proceedings that will test the strength of the evidence and the credibility of witnesses. The 9-day gap and Mary Buchanan's testimony have reshaped the narrative from procedural to profoundly human. The resurfacing of prior child cruelty allegations has elevated public demand for accountability and reform. As the legal process unfolds, the public should focus on sharing verified tips and supporting institutions that genuinely protect children, not on rumor. Emmanuel's absence is an irrevocable loss. The obligation now rests on the justice system, on social services, and on every member of the community to ensure that silence never again becomes a child's fate. If you have verifiable information relevant to this investigation, contact the Riverside County Sheriff's Homicide Detail. Your tip could be the piece that brings truth and closure.